All right, everybody. This is Anthony Reeves, attorney at law, and I'm going to give you my legal beat tip of the day. Today, we're going to talk about medical records and Social Security. Now, most of you have been told this, and if you haven't, let me throw out a little point here. You bear the responsibility of proving you're disabled. It's not Social Security's responsibility. You do, which means you must show that your condition prevents you from doing work, if you're an adult, and if you're a child, you must show that your child is not functioning at the same level as a child in this particular age group. But in any event, you bear the responsibility of proving that you're disabled. How do you do that? Medical records. Go to getting medical treatment, and of course, the medical records. Now, let me walk you through the Social Security disability process and give you an understanding of how that plays out. Okay, so you go into Social Security office, or you go online, you file your application. Great. You get your application started, that gets the ball rolling. Most people don't realize is that we operate in what I like to call a two-tier system, meaning Social Security makes the technical decision, and then what they do is once they've determined from a technical standpoint you qualify for one of their programs, they then send your file off for a medical determination. Now, the federal government has contracted with state agencies, which is called the Disability Determination Services, in order to do the medical development of your case. That means there's a state agency that's responsible for sending out forms to you and your loved ones, for scheduling appointments with doctors, for Social Security doctors, and getting copies of your medical records. Now, listen to these points as I address them clearly along the way. When you first start your application, you need to tell Social Security all the doctors that you're going to see. That's fairly easy. The biggest thing comes up is when people say, okay, a couple months later, you're going to a new doctor. Who do I tell? Well, here's what you need to do to make sure the Social Security has the appropriate records. If you've just started your case and you have not received a letter from the Disability Determination Services, and it'll say it on there, it's either the Office of Disability Determination or Disability Determination Services. If you have not received that letter, you need to contact Social Security whenever you have a new update. Now, to cover yourself at some point in time, you're going to get letter or letters from the Disability Determination Services, whether it be because they want you to give them more information, whether it be because they need you to give them the names of some people to talk to, whether it be for appointments, whatever. When you get that letter from them, that's the agency connected with Social Security that's responsible for updating your file. So, what is that telling you? Well, if you have new updates for medical records, you need to call the Disability Determination Services, not Social Security. Now, why do I tell you that? Well, because what happens is once Social Security does their technical portion, they send your case over to them for the medical workup. So, you're actually adding a step if you go to Social Security, ask them to put that information in your file, and then have them transfer it to them. And just in case it doesn't get there, you don't want to be mad because what happens is that a lot of times people say, I called Social Security and the medical records from the doctor I went to wasn't in the decision that denied me. Well, sometimes the one hand doesn't talk to the other. It happens on occasion, happens in private sector as well as public sector. But to cover your bases, what you want to do is you want to contact the Disability Determination Services. Now you will know this because they'll send you a letter. So don't throw those letters away. Keep because there's phone numbers on there. Now, here's a couple of things that you also need to be aware of. Social Security or the Disability Determination Services, they work on a budget. So they're not going to be dropping big dollars for all of your records. So if you're talking about because they let me pause for a second. Say for instance you went to a hospital. Social Security said we need the records from the hospital. The hospital's like, well, we're going to charge you $500 to give you all for us to get all those records. Social Security's not going to pay $500 for all those records, and you're like, well, that sucks because if I have the responsibility of proving I'm disabled, what do I do if they're not going to get those records? Keep in mind, most companies, whether it be doctors, clinics, and so forth, they deal with federal agencies all the time, so they usually give them a break in terms of how much they're going to charge. Some facilities don't. Seriously, some don't. And Social Security, typically, they have a dollar amount that they're going to put in terms of getting copies of the medical records. Now, if you've got a representative, it works out great because sometimes your representative will go and get those records for you. Keep in mind, some representatives will going to charge you for those records, so they'll either one make you pay them up front, or if they go get those records, you're going to have to reimburse them. But let's just go rule of thumb. Rule of thumb is this: if you're applying for Social Security disability benefits and if you're at the early phases, because some states you have to get denied twice by the local office, some states only once. But when your case is at the local office level, they will get your medical records for you as long as the Disability Determination Services is still working with the local office at the local office level. That means your initial application, or if you've been denied once and there's a second appeal, it's what we call the reconsideration level. And you'll know if you're at the reconsideration or the initial level because if you when you file your application, that's the initial level. If you get a denial letter and it says you can file a request for reconsideration, that's the recon level. They will still update your file. If you get that first denial and you see on there that they didn't have some of your old records or records that you told them about, make sure you update them. People, I cannot emphasize this enough. Social Security will get your medical records for you, but they can't get them if you don't tell them. And remember, at the initial local office level or the recon local office level, there is a state agency that gets the medical records. So when you start getting letters from those agencies telling you that they need stuff, keep those numbers so that if Social Security, if you get some updated medical records, you contact the Disability Determination Services. Tell them, ask for the person's name, ask them where you can fax it to, put it to their attention so that this way you know. Okay, that is the local office level. So you get denied, maybe once and you go to a hearing, or twice you go to a hearing. I need to make this point abundantly clear to you. When you get to the point where you have to go before a judge, Social Security will not get any more records for you from that point forward. From that point forward, you have to get those records. That's your responsibility. Nobody else's, but yours. So when you come before the judge and you go by yourself, or you go with a representative who basically requires you to pay them up front and you choose not to pay because you're like, no, I'm not going to pay for those records. I don't have the money. The average case, I think right now, I think the fastest hearing office in the country has a hearing in about 270 days, I think. So well, basically what I'm telling you here is the slowest office right now to have a hearing date is still a couple of months, about 2 months shy of a year. So if you've been going to the doctor the whole time, guess what? If the last record they have is from the local office, which was done back over a year ago, that's all they're going to have. So don't walk into that hearing with an attitude talking about, look here, I've been going to the doctor. Where are your records? Well, Social Security. No, 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 no. At the hearing level, they stop. So that means you need to get those records and you need to be prepared to get those records. And so I always stress that to people so that they don't get their feelings hurt when they walk into the hearing and they're like, well, I don't understand. That's why I tell people at the early phases, you want to let Social Security know as much as possible. Be aggressive about letting them know. And if you have a representative who is informing Social Security, you need to let your representative know as well. At the hearing level, if you go before a judge, there is no requirement for them to get your medical records. If you get denied by a judge and it goes to the appeals council, here's where medical records get a little tricky. Because sometimes what people want to do is they want to barrage the appeals council with a lot of medical records. And I always tell people, typically at the appeals council level, they're not taking a fresh look at the medical records. They're looking at it as, what did the judge have before he or she, and did they make an error of law in making their decision? Now, here's how you work with those records after the fact. Let's say, for instance, that you've gone to a primary doctor and you got all those records to the judge and the judge denied you, but then the primary doctor sends you to a neurologist who says, you know what, you're disabled because the neurologist and their expertise based on your condition determine you're disabled. Well, that's new because the neurologist wasn't available at the time you had the hearing. It's material, it goes to your condition, and the good reason that you didn't have it before for the hearing is because You had only just been recently sent there. So that's something the appeals council is going to want to have, because they're going to say, looking at this evidence, maybe the judge, if he or she had this, may have made a different determination with regards to your condition. That's a whole nother story. But let me just kind of break medical records down to their purest essence. At the local office level, you got to make sure they have all the medical information. They'll get your medical records for you. Once you've been denied once or twice, depending on what state you're in, you bear the responsibility of getting your medical records to Social Security from that point forward. Keep that in mind. When I mean that point forward, I mean throughout the rest of the process. Whether you go before a judge, whether you have to appeal before the appeals council, or even if you have to go into federal court. The moment you have to ask for a hearing, the responsibility of Social Security to get your medical records stops. Keep that in mind, because I don't want anybody out there cuckoo for Cocoa Puffs because they think that the responsibility for Social Security to get their medical records is continuous. It is not. Keep in mind, you bear the responsibility of proving you're disabled, and the only way you can do it is with medical records. Be aware of where Social Security has responsibilities to get your medical records and where yours actually begins as well. Hopefully that helped you. Again, you can always find more information at legalbeat.anthonyreeves.com, or you can check me out at reevesfirm.com. Hope this helped you out. Have a wonderful day.